So Terry came to us after he was arrested for DUI. He gave a breath test. He blew 2.5 times the legal limit. Terry made a smart move, called us, we took over the case, and we beat it. We got it reduced to reckless driving. It's a huge win. Terry's super happy. I'm Adam Rossen from the Rossen Law Firm, and today we're going to talk about another great case result that we had for our client, Terry. Now, Terry was arrested for DUI, and we were not the first lawyer that Terry had. So when Terry got arrested and he got out of jail, he, found a lawyer who does a little bit of a lot of things. So this lawyer handles personal injury, and this lawyer handles a little bit of criminal law, and that lawyer handled some other areas of law. And he really didn't have the experience with DUI cases. DUI law is very technical. You really need to know the ins and the outs of DUI law. And after basically doing nothing for a year or so for Terry's case, he told Terry, he said, listen, you blew 2.5 times the legal limit. There's no defenses, you have to plead. And Terry thought about it, everything, and he said, but wait, I don't think I'm guilty, and I want to keep fighting. So what he did is he came to us for a legal second opinion. And I looked at everything, and I said, listen, Terry, it's going to be a hard case, but I see 2 or 3 different things that we can go deep on and attack on legal motions and issues that we have that were not explored by your current attorney. I said, Terry, it's up to you. What do you want to do? And he said, Adam, I want to try. If I can't beat the case, you can't beat the case, I at least want to know that I did everything possible to try. And so we welcomed him on board. He hired us. We took the case over. And one of the very first things that we did on this case was hire an expert witness. And we usually don't do that on regular misdemeanor first DUIs. Very rare. Usually we save those for vehicular homicide cases, for DUI manslaughter cases. But Terry's case had some really good legal issues, and he wanted us to go guns blazing, basically, and do everything we could. So we hired our expert witness. The issue were basically 2 issues. Terry was stopped at a light, and he made a left turn. And when he made this left turn onto the other street, he crossed the solid white line. Well, that's actually not illegal in the state of Florida. And the way that the prosecutors and the police charged him was incorrect. So we went deep and we explored that issue. The second issue was they said that his tints on his car were illegal. And a year before, when Terry got out of jail, Terry went to have his tints tested, and they came back as 100% legal. Now, the problem on his case was Terry was arrested in Margate, and currently Margate still does not have body cameras, Margate Police Department. They don't have body cameras, they don't have in-car cameras. So there was no evidence showing if they actually did the tint test, and there was no evidence showing what those results really were. So going back to our expert witness, we had our expert witness take Terry's car and conduct his own tests, and we videotaped it. And of course, just like Terry said, his tints were 100% legal. So what do? We filed a motion to suppress. And what a motion to suppress says, generally speaking, is that the police violated his either 4th, 5th, or 6th Amendment rights. And in this particular case, we said that the police violated his 4th Amendment rights against an illegal search or an illegal seizure. And by filing that motion, we went from criminal defense to criminal offense. And what I mean by that is we now put the prosecutors on defense. They had to defend against the motion. All of the pressure was now on the prosecutors. So here we are, where Terry was accused for DUI. He blew 2.5 times the legal limit. He blew over a .20, very high. And the prosecutors were thinking this case was a slam dunk from the beginning. And by us filing that motion, it flips things around and they have to defend against it. And we knew that had we won this motion, Terry's case would have completely gone away. He would have been found not guilty. We would have won everything. But had we lost this motion, Terry's chances at trial would not have been very good. And the prosecutors knew that too. So by us filing this motion and putting the pressure on them, actually days before we were supposed to have the motion heard by the judge, we came to an agreement for a reduced charge of reckless driving. And this was a great result, I think, for both parties. The prosecutors got something out of the case, and Terry was so happy, right? A bird in the hand is worth two in the bush, if you've ever heard that phrase before. We won. When you get a reckless driving, sure, Terry had to do a little bit of probation. It was a criminal charge, but he won. He wasn't convicted of DUI. He didn't have to have the FR44 insurance, which can cost up to $18,000 over 3 years. If this ever happens to him again, Terry will be prosecuted as a first DUI instead of a second DUI. So for 95% of our clients, when we're able to get them a reckless driving, that's a huge win, and we usually tell our clients not to say no to that. He was very happy. And again, that's the importance, this case, of making sure that you have attorneys that really know DUI, not just criminal law, but DUI law. Because an attorney who handles a murder case might not be equipped to handle a DUI case. And Terry realized that throughout the case, made the smart decision to come to us for a legal second opinion, made the smart decision to have us take over the case, and we won. And he's very, very, very happy. He's doing very well. He actually got a promotion at his job. Life is good, and we couldn't be happier for him. And this is what we do. We help good people when bad things happen to them. If there's any questions, issues, concerns, by anybody, give us a call, 754-206-6200.